First things first, it's actually illegal to either use the money that is in the bank or just use any property that is owned or registered under the deceased.
In the event that, let's say, your parent died, or let's say your spouse died, without having left a will.
Okay, first get a lawyer to make an application for you.
Your lawyer will probably tell you to go cars, because now you have land, you have the cars, and you have land and the cars, and maybe you have shares. Hello and welcome to the Sisters-in-Law podcast. My name is Beverly Mokaya and I'm here with
Aquila Mokaya. In this podcast, we discuss matters law.
From navigating family law and inheritance matters, to talking about tax law, contracts, employment law, and major developments in law that you're better off knowing about, we've got you covered.
Remember to share, subscribe, and comment down below. So on this episode, we'll be discussing on matters of inheritance.
So to help you debunk the different steps and procedures and what you need to know in the event that, let's say, your parent died, or let's say your spouse died without having left a will, we're going to have a story of someone called Peter. We'll just call him Peter, right? It's not. Yeah. It's a fictional name, a fictional character, but this story is a real story. You just don't want to use
their names.
So think with me for a second. Yeah, this man, he was 50 years old. He had cancer. He was, let's say, in Nairobi hospital. He died, right? There are medical bills that have piled up. This guy needs to be buried ASAP. And he has left behind property. He has left money in a bank account. Let's work with maybe KCB. And he has a farm where, let's say, they had planted maize, and this maize needs to be harvested. It's ripe for harvest. He left behind 2 wives. One, whom he married under the normal laws of Kenya, like the right laws. He went to, let's say, a church, and they got married. There's a marriage certificate to that effect. And one who was just a cohabitee. A cohabitee is someone, let's say, who a come we stay. Yeah, and he had children with both of these wives, and he also had another child out of wedlock. So we just want to use this person as an example to show you, in the event that maybe you're a child in this instance, or the wife of this man, what would you do in the event that he has just died abruptly? How do you go about it? Like, what are the steps that you need to take?
First things first, it's actually illegal to either use the money that is in the bank or just use any property that is owned or registered under the deceased Peter's name at the beginning without the authority of the court.
Yeah.
So now, in general, you must always apply for a grant, so which gives you the authority to either use, collect, or even divide amongst yourselves.
Yeah.
If you do it without the grant, then it's an offense. Intermeddling offense here.
So in short, you're not allowed to harvest the maize. Of course, maybe someone might harvest, because who will catch up with you, yeah? But you're not allowed to harvest the maize. You're not allowed to withdraw the money in the bank, even if you know the PIN. You're not allowed to touch any property of his, to sell the land, to sell the cars, or just use any property of his until you go to court and get the right documents for it.
Yeah, so first things first, we need to clear the hospital bills. So we'll make an application before court. Okay, first get a lawyer to make an application for you.
Your lawyer will probably tell you to go see the chief.
Yeah, to get a letter from the chief that says the chief knows the deceased, knows acknowledges that the deceased was living in the area, the children of the deceased, and the properties. So he will all list the dependents, like maybe the children and the wives that he knows.
Yeah.
So you'll have to attach that letter of the chief first.
In anything that you put in court. Yeah. So once you get that letter, remember we've said that this person has died and the wife doesn't have money to
Pay the hospital
pay the
bills.
hospital bills,
Yeah,
and
for the
mostly they won't
burial.
release the body until you've cleared the bills.
Yes.
It's urgent. The widow does not have money, and yet she cannot access
The money in the
money
bank.
in the bank.
Yes.
Yeah, for her to complete the hospital bills, and also to
Cater for the burial.
cater for the burial expenses.
Yeah.
So now there's usually a long process, like we said. Aquila mentioned something about you mentioned something about the grant. Yeah, a grant is that it's the authority. It's a document. It's just a simple document that you get from court that allows you to use and to dispose of the property of the
of a deceased,
of someone who has died,
who didn't have a will in this case.
Yeah, who
because
didn't
our
have.
guy didn't have a will.
Yeah. Okay, in this case, we're talking about the person who didn't leave behind a will, but even you would still need a grant for someone who left behind a will to be able to distribute the property according to the will. So the difference between this and maybe the person who left behind a will would be that you're not respecting the wishes of the dead. Yeah, in the sense that he didn't die having written that my land, say Kaputei North, number this and this and that is supposed to go to person X, and this is supposed to go to maybe a children's home or whatever. So now what will happen is you will need to distribute based on the dependents that he has left behind. Yeah. So like in this case where I talked about a grant, Cindy, like you're supposed to go get a grant, that document from court. But now it takes a long process. It takes a long time, let's say for 6 months or more.
6 to 8 months.
Yeah, 6 to 8 months generally. And yet you can't leave this body
at the hospital and not pay the bills.
You cannot leave the body in the mortuary. This person needs to be buried, and you need to pay for the hospital expenses.
Yeah. So, also, remember that we had not harvested the maize yet.
Yeah.
So we'll need an authority from court, now the grant that we have just talked about, to be able to give us the authority to harvest the maize, to collect and preserve.
Yeah.
Before now we do the total distribution of the property.
Yeah. So like now the lands and the cars. So now normally you would just you get a lawyer. You've already gone to the chief, right? So this is either in this the shorter processes regarding now payment of the burial expenses and the medical expenses and whatnot, and the maize in the farm. You don't necessarily need to be the wife. Even the son can do it. Like any dependent can do it. Yeah. So you will get the letter from the chief. Go to your lawyer. You have the death certificate, right? So go to your lawyer and tell them, of course, explain your issue, and then they will probably tell you that you need to pay some amount of money based on the fees that they'll charge you. And then they'll proceed to court for something called a limited grant. It's just for a short time, an authority limited to a specified time for you to be able to do those acts, like to get money from the bank to pay for the expenses, to harvest the maize and whatnot. And also in the event that you need to pay school fees. These are things that you don't have to wait for so long for you to get the actual grant.
Yeah.
It's actually called a grant of letters of administration, if you want to go, shine with legal jargon. Yeah, for you to, you don't have to wait for that long for you to do the preliminaries and the urgent stuff. Yeah.
So for the limited grant for the short urgent stuff that we need to do now, we'll need to get the lawyer, as you said, who will make an application before court. But this application is separate from the original application for letters of administration, grant of letters of administration that was made for the total property.
Yeah.
So this is just to get the small stuff done.
Yeah.
So you'll make an application with the death certificate, letter from the chief, proof that you are related to the deceased person.
So like in this case, maybe a marriage certificate or a birth certificate.
Either a marriage certificate or a birth certificate.
Yeah.
But also, it's important to also note that the chief must have stated you in that letter as a dependent. If you have not been stated, then it's going to be an issue or something like that.
Yeah. Yeah. So normally within that application, it usually takes around a week. It's called a certificate of urgency. Again, if you want to shine. So like it's called an application under a certificate of urgency. Your lawyer will just put the application in court, and within 6 days you'll have the orders that you need, for as long as you've attached the correct documents. So now that document that you get will enable you to be able to go with it to the bank, withdraw money, pay for the medical bills, pay for the medical expenses, maybe pay for school fees. And then now from there, you can now embark on the process, on the longer process of getting the grant of letters of administration to administer, or to administer is a simple term, to
like
administer the entire
oversee.
estate. Yeah.
Does it.
Because now you know you have land, you have the cars, and you have land and
Nice.
the cars, and maybe you have shares in a
In a
company.
company,
Yeah.
yeah.
Peter had shares in a company. Yeah. So now, after the burial, of course, you know, there's a lot of family feuds in such matters, and it's worse than you think, I promise you, based on the experiences that we've had
Yeah.
handling such clients. Yeah. So you would now, for the main process, what do you need? Remember, you got a letter from the chief, right? You need to have ownership documents
Yeah.
of the deceased. And at this point, I think I'll just say how important it is as a man or as a woman to disclose all your property. Because if you do not, and this property is somewhere, they can be taken. There's something called an unclaimed
Unclaimed
assets.
assets,
Yeah, they
yeah.
will claim them. So it will go to the state. Yeah. So like I said, make sure you disclose your property so that you don't leave your family in the better thing to do is to gift them when you're still alive.
Yeah.
Or write a will. Anytime you get property, let's say you acquire property, add it to your will. Yeah. But if you didn't do that, if you don't do that, if you don't believe in, you know, because if you don't believe in leaving a will behind, then you can just make sure you disclose all your property to your family members.
Yeah.
And you have the ownership documents where they can access them.
It's also very important to note who can place this application before court. Like this the major
the priority. There's a priority.
There's a priority list for this specific application.
Yeah.
So it's either a spouse of the deceased. So either it's a spouse or spouses who will do it either jointly or with the consent of the others. Just in case maybe the guy had, let's say, 10 wives, or we said 2 wives. So we'll need, maybe if it's one who's placing the application, then she must have consent from the other wife. But if the spouses, the wives are not maybe in the space, maybe they are sick or something, they're not in the space of making the application, then the children of the deceased can make the application. Then again, he had so many children. There must be consent from the wives stating that they are not able to make the application, but they're giving authority to this child to make the application. If the children do not make the application, now the public trustee can make the application for them to get the grant of letters of administration.
And at this point, I think it's important for us to clarify that children, we mean the children of the deceased who are of age. Yeah, over 18. Okay. So now, like I said, you need the ownership documents. What will happen? You will need the ownership documents, the letter from the chief, and what else do you need? That's all you need. The death certificate. Okay, so like I said, you will need the death certificate, the ownership documents, and the letter from the chief. From that, it will be taken to the lands registry. It will be registered, and then after that, you go back to court. I think it's just important for us to lay down this procedure, although your lawyer will explain it to you.
Yeah.
But there's a place I'm trying to get to. So after taking it back to court, you will need to advertise. You know, after the deputy registrar, or this is just a judicial officer, has confirmed that all the documents are correct, the rightful owner was the deceased, you guys are the dependents, all those things.
List,
yeah, there's a priority list, the documents are correctly filed. They will allow you to go and advertise in the Kenya Gazette. This is important in the event that there are people who can object to giving this to the issuing of this grant of letters
to state
of
whether either they were dependents.
Yeah.
If the child, the person who's objecting, could be must not be the child of the deceased.
Yeah.
That's also like an important point, not because where the deceased was taking care of any, even if it's a niece, a nephew, and was living with them 2 years prior to his death, then they also have a right to object as dependents. But they also have to show that they were dependents and to what level were they depending on this money.
Yeah. So now, a child that was even born out of wedlock is still a child. It's considered a child for purposes of inheritance laws. A wife, normally under Kenyan laws, it's illegal to contract another marriage if you have a legally registered marriage. Like let's say, for example, Peter had, I said he had 2 wives. One who was married under church, there's a marriage certificate, and one who was ampango wa kando. yeah, a cohabiting, yeah, a cohabitee, or a mpango I think it's mpango wa kando.
Yes.
Yeah, a mpango wa kando. So this mpango wa kando, under law, under marriage laws, she's not
a wife.
recognized as
Yes.
a wife. But now when it comes to inheritance, they're recognized.
Oh, to listen at the same time.
Yeah, they're recognized as a wife. So even if you had 5 mpango wa kandos and they all had children, they can object. If you had children outside, they can come
and still say that they were dependents because they are still your children. Of course, they'll have to do a DNA test and whatnot, and the birth certificate and that whole procedure, but they are still dependents for matters of succession.
Yeah, and for a cohabitee, for as long as you cohabited for a long time, people outside assumed
that you guys
you are together and you have a child in the process, more than one, or a child or more. Yeah, this person can come and say, for purposes of succession, for purposes of inheritance, I was a wife to the deceased person, and I'm also entitled. So now you see, when you go to the Kenya Gazette to advertise that we want to register for, we have applied for grants of letters of administration for the authority to manage or to administer the property of this person who died. And then a cohabitee sees it somewhere, or maybe they just hear from relatives that you guys are trying to get to the property, they can come to court and object.
And they'll be added as dependents as long as they can prove their dependency.
Yeah. So before now the court goes to decide the entire thing, they will determine this application first,
on the issue
if it's
of dependency,
legit and whatever. Yeah. So if there is no objection, or if after determining the objection, the court decides that you're going to get the grant of letters of administration. So normally after the period of 1 month, you'd be able to, the court will give you, it's called a grant of letters of administration. But that is not enough authority for you to, let's say, dispose of the land or sell the car, or, just use the property of the deceased now, as opposed to, we talked about the limited grant. That grant of letters of administration is not enough. You still need a confirmed grant. Until you have a certificate of confirmation of grant, you're still not allowed. You don't have authority, even if you are the wife. Sadly, that's not how the law works. Yeah. So between you getting the grant of letters of administration and the confirmed grant, it's usually a period of 6 months if there are no delays in court.
Yeah. So the period of 6 months, you're allowed to come up with a schedule of how you want the properties to be divided.
Yes.
So you are dividing between the dependents who are in the ones that we submitted in court, and if the ones who objected made it to the list of the dependents, now you can bring out a schedule where you divide, maybe this one will take this car, this will take this land, this will take blah 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 blah. And however, when you're deliberating on how to divide this property, you'll remember that we said we had minors. The man Peter had children who are of age, who are working, and also minors. So while you're doing this, the schedule of distribution, we're going to consider it's not going to be equal, because of course they're not equal. I mean, there are others who are like younger, who are probably in school and they need more money because of school fees and whatnot, as opposed to these older ones. So first, the property is going to be divided in a way that makes the younger ones who are still in school to get more than these ones who are not in, who are like working at this point in time. Yeah.
And of course, the distribution is up to you as a family, because now you have administrators. Remember, if you have a minor, if the deceased left a minor behind, you have to have more than one administrator. Normally, if everyone is a grown-up, you can just have one. Let's say one wife handles everything. But if there are minors, you have to have more than one. There have to be two. And then if you give these minors any property, of course, because if you're not over 18, you don't have capacity to own property. The administrators will hold it in trust for you, for the child now, until they become of age. Yeah, so normally between the period of 6 months is to provide time for the family to just deliberate on how the property will be distributed, and then you go back to court and file the schedule of distribution, and then the court will now give the confirmed grant of letters of administration. Remember, the court will mostly not go into the nitty-gritties of what you have written, because it's a family thing, a family issue. So for as long as no one complains, the court will mostly just pass it, and you will have the certificate of confirmed grant, and you will be free to administer the property of the deceased as you deem fit.
There's something that we had not talked about, like if the ones who are going to object, let's say there's a child outside wedlock who did not make to object at the 1 month stage, they can always make an application for revocation of the grant.
Yes.
So if they fit to be a dependent, the grant can be revoked after confirmation of the grant.
Yeah, and even at any stage after advertising, like you've advertised, you've gone and gotten a grant, even it has not been confirmed yet. Any other dependent, and by the way, you remember when we talked about objection, anyone, the people who can object, we said it can either be a child who was born out of wedlock, a cohabitee, and there's this important person that we didn't mention. For example, the deceased had sold land to someone.
By the way.
This person paid the money and the land was not transferred to this person yet.
Transfer, yes. Yeah.
So this person can also come in as an objector. Yeah.
Okay.
Exactly. But of course, we'd want most of these things, instead of objecting and going to court, like if your lawyers can come into a settlement and agree to just add the administrators, to just add the dependents, then it would be better.
So if you followed those steps that we have discussed, and then you're issued with the grant confirmation of grant of letters of administration, then now you can distribute the property or even sell the land if you are given that specific property.
Yeah.
Yeah.
So it is always important for you to get a lawyer to do these things. Just as a small breakdown, go to the chief. That's your first stop. Go to the chief to make sure to get a letter that says, I know this person, and this person died. He used to live in my village. He left behind so and so and so and so. Then so and so and so and so. In this case, now the wife or the children can go to court, get the limited grant for you to be able to administer the property urgently, maybe harvest or pay for medical expenses and pay for the burial expenses and school fees and things like that. After which, now go to the long process, where you're supposed now to get the grant of letters of administration, and then do a distribution schedule. Probably you need a family meeting for that. And then after that, file it in court, get your certificate of confirmation of, it's such a mouthful. Get your certificate of confirmation of grant, and with that, you're able to administer your estate. So I think we're done for today. I hope you enjoyed this episode.
Remember to share, like, subscribe, and comment down below. Also, you could comment on any point you need clarification on, and or other questions that you'd like for us to discuss.
Thank you for watching. Bye.
Bye.